Good evening, this is John Milburn for Laws 13010, Evidence and Proof, and we're into week 6 of Term 1 2018. Tonight we're dealing with documentary and real evidence, and you'll need to consider the content of your textbook in that regard. As always, have a look at the weekly problems. Try to upload a response to those weekly problems on Moodle. I think, Vivian, you're very good at doing that, so thank you very much for that. And I appreciate your attendance tonight. I appreciate, Sam, you attending as well tonight. It's very important that we do have attendance. And for those that are watching or listening to this recorded session, please consider joining us on a Wednesday evening. It's always better if we have an interactive session. Now, the penalty, of course, for not having many people online is that you tend to listen to me. So if you find that a bit dull, a bit monotonous, then please join us. Anyway, enough of that. So documentary and real evidence is actually closely aligned to hearsay evidence as well. Might seem a bit odd. Why are we talking about hearsay within the context of documentary or real evidence? Well, the fact is that in order to have something introduced into evidence that is a document or something that is real evidence, we need someone to put it there. And it's essentially taking something that is out of court and trying to make it probative towards a case. So documents are very widely defined. I'm sure you've seen that in the Queensland Act. So when I talk about the Queensland Act, of course, I'm talking about the Evidence Act, 1977. And when we look at the definition of documents, we go to, unsurprisingly, the dictionary. And you'll see in the dictionary the very wide interpretation of what is a document. I guess in describing a document, we can really talk about it being a vessel or a platform for providing something which contains information or data. So writing in a typical sense, something in written form is a document, but it goes much beyond that. Books, maps, plans, photographs, labels, discs, USBs, films, records, photographs. So these are all things that are documents because they contain data. They contain information. And we're not so much concerned in documentary evidence about what the vessel is, what the platform, the physical vessel for containing this data. We're actually interested in the content. We're interested in the words, what it conveys, or even the message, the photograph, as opposed to real evidence, which is where we're actually interested in the thing, aren't we? So if it's real evidence, we're interested in the knife. It may have some wording on it, that may have some evidentiary value as a document, but we're really interested in the knife. We're interested in the baseball bat. We're interested in the thing, which is the important piece of the evidence. So whether it's a document or whether it's real evidence, in order for it to be introduced as evidence, we need someone to say, here's what it is, here's my relationship to the thing, and effectively you're authenticating that as a witness. Now, why do we talk about hearsay? Well, hearsay is essentially any out-of-court statement that expressly or impliedly, by insertion, aims to prove something that is true. So generally, hearsay evidence is something which is out of court, and documents and real evidence are out of court, aren't they? So there's that tie-in between documents and real evidence and hearsay, as opposed to oral evidence, which is the evidence of a witness given from his or her recollection using his or her own five senses. So we need someone to authenticate the document, and we need to consider that within the definition of document and real evidence that you'll find in the Act. All right, so when it comes to hearsay evidence, just bear in mind, probably for the next 5 weeks, we'll be doing hearsay, hearsay, hearsay. It's a big part of the unit, and rightly so. But to prepare for this, I'm going to ask that you consider Chapter 10 of your text, which deals with hearsay under statute. And you'll see in there the definition of hearsay. You'll get a feel for the statutory scheme of hearsay under both the Evidence Act Commonwealth 1995, and the Queensland Act 1977. In terms of the Queensland statutory scheme, I'd ask that you look at sections 92 to 103 for information about the legal position regarding admissibility of statements and representations. So why am I talking about that in the context of documents? Well, you'll see that when those sections deal with the admissibility of documentary evidence as to facts in issue. That's section 92. And this is in the criminal, this is in any proceeding which is not criminal. Now, section 93 also deals with the admissibility of documentary evidence as to facts in issue, but it does so in the context of criminal law proceedings. 93A deals with statements made before proceedings by a child or person with impairment. So again, we're talking about some sort of documentary evidence there. We're talking about a statement in that context. And going further, an important provision relates to section 95, which deals with the admissibility of statements in documents or things produced by a process or device. And that is particularly important because where direct oral evidence of a fact would have been admissible, a statement contained in a document or a thing produced, wholly or partly by a device or process, and tending to establish that the fact is admissible as part of the evidence of that fact. So have a look at section 95 because it effectively provides for certification of certain documentary information which can then become admissible, not just for the fact of the document, but admissible in terms of the content, admissible in terms of being probative to proving something which is a fact in issue. Also look at section 95A, which deals with the very specific DNA evidentiary certificate. And we see a lot of criminal law relies on certification of documentary evidence. But bear in mind that there are some riders to this. Section 102 provides that there is the issue of weight to be attached to evidence. And in estimating the weight, if any, to be attached to a statement rendered admissible by evidence in this part, regard shall be had in all circumstances from which an inference can be reasonably drawn to the accuracy or otherwise of the statement. So if you're looking from the perspective of defence primarily, you want to keep in mind section 102 so that you have an opportunity to not necessarily attack the admissibility of the documentary evidence, but importantly attack the weight to which the arbiter of fact can consider the value of that evidence from a probative perspective. Oh, I'm doing a lot of talking, but you get the idea. So what we're talking about is documents, we're talking about statements, we're talking about certification of material information, we're talking about authentication through the witness giving oral evidence, and we're talking about the weight that can be given to certain documents which are provided by way of evidence in that regard. So the statute makes it relatively easy for documents to be introduced as evidence which is intended to prove the accuracy of the information contained within the statement, and it provides for that mechanism to do so. So the key sections, have a look at section, and I'm talking about the Queensland Act now. Key sections 92, 93, 93A, 93B, 95, 95A, and I'd also have a good look at 102. Now, I'm just going to have a sip of tea. Are there any questions? You don't have to. All right, well, let's press on. But bear in mind, of course, that it's not just any document that can be introduced into evidence. Have a look at, for example, the riders. So in 92, it says, talking about civil proceedings, not criminal proceedings, Where direct oral evidence of a fact would be admissible, then any statement contained in a document tending to establish that fact will be admissible in certain circumstances. So remember that there's the threshold there, and that is that the content of the material has to be such that it would be admissible if it was given by direct oral evidence of that fact. So there's always a little threshold. And it strikes me that if you're really studying this sort of area carefully and you're minded to do so, flowcharts would be a really good way of understanding and then remembering. So if you're dealing with a factual issue and you know that, for example, it's a civil case and Section 92 is likely to be relevant to the provision, if you go into answering that question and you've already prepared a flowchart and you can see that there are conditions and riders, it may well help you in terms of answering that question. Just a thought. Everyone's different in terms of how they might learn. Right, so Section 92, we'll just talk about that for a bit longer. So Section 92 is a critical part of evidentiary material for documents in civil matters. So what does it do? What does Section 92 do? It permits the admission into evidence in civil cases of two types of hearsay in documentary form. Now, in both cases by a person with personal knowledge. So look at Section 92(1)(a), which deals with essentially first-hand hearsay. That is a statement made by the maker who has personal knowledge of the content. Why do I say it's hearsay? Well, the material that contained within the document is a statement that's made out of court, not under oath. So therefore, it is essentially hearsay. We say it's first-hand hearsay because it's material made by the person who has personal knowledge of the content. So that's 92(1)(a). 92(1)(b) is also a type of, permits the admission into evidence of this hearsay in documentary form, but it is in circumstances where the content has been recorded or compiled in the course of an undertaking based on information supplied by a person who had personal knowledge of what was being recorded. Okay, so it's not the maker of the material, but it was something that was produced in the course of an undertaking based on information supplied by a person who had personal knowledge. So let's explain that and give an example. All right, so it's a bit tough. You need to get your head around this a bit. So just to recap, what we're talking about is something contained within a document. We want to prove the content of the material, the data, the words typically, in the document. We know we have to have someone come to court and authenticate that document. 92(1)(a) in a civil case says, look, the person who had personal knowledge, or the maker, if they had personal knowledge, can do so. 92(1)(b) says you can get someone who recorded or compiled in the course of the undertaking based on information supplied by a person who had personal knowledge. Okay, so an example, because they're not mutually exclusive. They can overlap where, for example, the duty manager of a hotel makes a report in the establishment's incident book. And this is out of your text. This is both a statement where the maker had personal knowledge of the content, and the statement is now information recorded in the course of the undertaking. So the undertaking is, in this instance, the business. So the duty manager knows something personally, but records it as part of the business operation, in this case, which is part of the undertaking. And now it's a record prepared in the course of the undertaking, so it broadens the scope of how people can introduce it admissibly into evidence. Okay, so just work through that, because if you're given a problem to solve, you may not necessarily be given a hint to say, have a look at section 92(1)(b. That's going to be relevant in these circumstances. You're just given a problem and you have to then work it back to the relevant section. Now, I mentioned that there's a preliminary rider. The statement would have to have been admissible if it was given in direct oral form. So what does that mean? Well, what's inadmissible as evidence, even if it's given in direct oral form? There are probably two that we immediately think of. That is, for example, if it was hearsay or it was opinion evidence, it was a bit more than that, if it was privileged, for example. So if something in a document is effectively an opinion, that would not be admissible if it was given in direct oral form usually. So therefore, the fact that it's in a document doesn't improve its quality or its standing from an evidentiary perspective. It might be in writing, but it's still an opinion. Therefore, that's not admissible. Likewise, if it was second-hand hearsay, not admissible in oral form, not admissible in documentary form. Okay. Now, I gave the example, which was from the text of the duty manager at a hotel. Hotel being a business. Business is something which is included in the very wide definition of undertaking. So have a look at Schedule 3 of the Evidence Act Queensland. It defines what is meant by undertaking, and it includes businesses, professions, occupations, calling, trade, whether carried on by the Crown, for profit, not for profit, or Queensland or elsewhere. And the courts will interpret that term very widely. So have a look at Kenny against nominal defendant, and there was an issue of something being recorded in a police officer's notebook, and that was something that was the subject of that trial. So the other thing is that you've got to call in 92(1) the maker or the supplier of the information as a witness. So the maker, when we're talking about 92(1)(a), the supplier, when we're talking about 92(1)(b). So you've still got to call that person as a witness to effectively authenticate the material which is in documentary form, to enable the documentary material to have evidentiary value. So the significance of Section 92 lies in the exception to the ostensible requirement. There are 6 instances where the maker or the supplier need not be called as a witness. And in those circumstances, the document will be admissible as proof of its content. That is, an exception to the hearsay rule. So the general rule is you've got to call the maker or supplier of the witness. That's 92(1)(a), 92(1)(b). But if you look further, it goes on to say that there are some exceptions. Always seems to be exceptions, doesn't there? That's why you've got lawyers, the old joke. I'd love to find just a one-handed lawyer, because lawyers say, well, on this basis it's this, but on the other hand, and people hate when you say on the other hand, because they say, can't you just give me a straight answer? But it tends not to be. So if you look at Section 92, you'll see that there are some exceptions, and that's in Section 92, subsection 2. So when can you introduce a document as proof of its content, that is, an exception to the hearsay rule, even though the maker or the supplier is not called as a witness? So you'll see those separate circumstances there. I won't go through them. I'll leave you to read that for yourself. Now, bear in mind, of course, that all of this is subject to the issue of the weight to which the court is entitled to consider the material. And effectively, that means that the proportionality test applies, which you should always think about the Brigginshaw test in that consequence. So always think about Brigginshaw in terms of the extent to which the court needs to be satisfied even on the balance of probabilities. Okay, the other thing is Section 92 doesn't apply to criminal proceedings. And there's a case there about customs officers, whether that was criminal or not. Now, the counterpart provision of 92 for criminal matters is 93, and Section 93 applies for criminal cases only. So where direct oral evidence or a fact would be admissible, a statement contained in a document that tends to establish that fact will be admissible if, and it's broader here, the document forms part of a record relating to a trade or business and was made in the course of that trade or business, whether directly or indirectly, and the person may have reasonably been supposed to have personal knowledge of the matters contained, and the person who supplied the information is dead, unfit, out of the state, cannot reasonably supposed to have given the evidence, or may not have a recollection of the matters. So basically, it's a different test. Now, it appears, I guess, in a way, that 92 and 93 are similar, but there are some distinct differences. So when you're talking, this is a really important point. So when we're talking about documentary evidence, which is essentially a form of hearsay, the law through the Evidence Act, 92 and 93, allows that document to be admitted to evidence to prove the fact of what's contained in the document, but different rules apply between the two. Right, so what are the 6 differences? The first is that Section 93 has no equivalent of 92(1)(a). That is, there's no provision that allows into evidence a statement of its maker, whether or not it's part of the record. So 93 effectively only applies to record statements. Number 2, 93 applies to narrower category of records than 92. It's limited only to those which are part of a trade or business. In 93, there's no equivalent of the final 2 grounds for admitting a record in the absence of the supplier of the information. That does exist in 92. So there's no equivalent of 92 subsection 3, and there's no equivalent of 92 subsection 4 in Section 93. And finally, under Section 93, there's no need to call the maker or the supplier of a document to give evidence for it to be admissible as evidence of the facts contained within it. So there's different rules that apply to civil law and criminal law. And one of those differences is the limited interpretation of trade or business. So have a look at that as opposed to the definition of undertaking in Section 92. Oh, that's a lot of words. I guess really what we need you to do is look carefully at sections 92, 93, and it would be useful to consider a flowchart, and it would be very useful to create a list of the differences between 92 and 93. And I think there are 6 that you need to identify. All right, we might move on. 93A is important because it deals with out of court statements by children or witnesses with impairment of the mind. So the effect of 93A in criminal trials is that where the person covered by that section is the victim, probably in most cases of alleged sexual offences, it forms part of a package, an evidentiary package. So you must read Section 93A in conjunction with Section 21A. So 93A and Section 21A work together. And it's all about the way in which the evidence of victims, primarily children, primarily in sex offence matters, can have their evidence presented to the court. So it's part of a package. The way it works is this. In a Section 21A hearing, there is a special room, a witness room, and the witness is with a support person, and they are beamed in, if I can use that term, into the courtroom by closed-circuit TV, CCTV. There are special screens and there's different rules that apply. And the witness is cross-examined, examined and cross-examined by defence counsel who are remote, so that the idea is that the victim in those circumstances will be less intimidated by the circumstances and able to more freely and voluntarily provide their evidence, their information. So it's a protective mechanism. And the idea of 93A and 21A collectively as a package, if you like, is to ensure that the victim has a voice and the degree of intimidation or confrontation is reduced to a minimum. So have a look at sections, look at 21A and look at sections 21AA through to 21AX, which deals with the evidence of affected children, and then have a look at Division 4B, which is 21AY to 21AZC in that regard. Now, Samantha says, do you think the Royal Commission into Child Abuse will have any impact on these sections in the future? I suspect not, because these sections now, I think, are pretty tried and true. They're tried and true. The sections are relatively new innovations. They came into effect as a result of complaints made about particularly the way in which children had to endure cross-examination in certain circumstances. And I think that they now strike an appropriate balance between protecting the rights of the children and ensuring that the person who is accused has an opportunity to ask questions of and, as it were, meet their accuser. So I don't think that there'll be any further changes, but it's a really good question. Thank you, Sam. All right, so what we've discussed so far on this point is it's very important that you look at Section 21A. You'll see that Section 21A deals with the evidence of special witnesses. And it's not just age, it can go beyond that. It can be level of understanding or even cultural backgrounds. So if we have someone who's a special witness, you'll need to look at the definition, and it could be a child under the age of 16 or a person who in the court's opinion would, because of mental, intellectual or physical impairment, be likely to be disadvantaged as a witness or would likely suffer emotional trauma or be intimidated so as to be disadvantaged as a witness. So Section 21A and the definition of special witness is quite wide, and you need to consider that. All right, so I mentioned that Section 21A and Section 93A work together. And 93A provides for an opportunity for a statement to be tendered as evidence, and tendered as evidence with a view to proving the content as being truthful and probative. But as you might expect, there are conditions. So what are the conditions that are set out in the legislation which must be satisfied before a statement of that nature can be admitted into evidence? Now, there are 4 of them. The first is that the maker of the statement was, at the time of making it, either a child or a person with an impairment of the mind. That's the first thing. Second is, the maker of the statement had personal knowledge of its content. The third, the child or the intellectually impaired person is available to give evidence in the proceedings. And number 4, the statement in question is in a document. So they're the elements. When in practice, what happens is this: the judge will give a direction to the jury regarding the evidence which is contained in a Section 93A statement. So you'll hear this a lot around the courts. You'll hear Section 21A hearings, you hear Section 93A statements. So 93A statement is the statement of a child or an affected witness, and it's tendered in evidence to prove the content is true. But in fairness, the judge will give a direction to the jury. And Section 21AW actually requires the trial judge to direct the jury that evidence in a statement admitted under Section 93A must not be regarded as carrying any more or any less weight simply because it's admitted in that form as opposed to oral evidence. So Section 21A says don't give it any more or less weight, just treat it as part of the evidence generally. If you're defence counsel though, and you're considering Section 21A and 93A statements, keep in mind the overriding discretion contained in Section 130 of the Evidence Act, which allows a trial judge to exclude any item of evidence at all if they're satisfied it would be unfair to the accused to admit it. So that's always got to be on your mind. Put a big red mark next to Section 130 somehow in your notes, and it would be a good idea on almost any evidence question dealing with admissibility as a rider to mention Section 130, because that's always going to be part of your mindset. All right, so 93B deals with that of court statements in prescribed criminal proceedings. And 95 deals with documentary hearsay generated by a computer. Really important, saves an awful lot of time. But basically, in order to admit something to prove the content of the statement, there are some conditions. So what are the conditions that apply to enable computer-generated hearsay evidence to be admissible? That was a long phrase, wasn't it? Computer-generated hearsay evidence contained within a document. Of course, if it's computer-generated, I guess it has to be, I suppose it could be oral, but we're really talking about documentary evidence. Okay, so the document containing the statement has to have been produced by a computer during a period where the computer was regularly used to store and process information in connection with the activities of the person employing it. That's number one. Number two, the information of the kind contained in the statement must be derived or was regularly supplied to the computer over that period. Number three, throughout the material part, the computer was operating properly. And number four, the information contained in the statement is information supplied to the computer in the ordinary course of the activities. What tends to happen is this. The document generated by the computer, which purports to be part of the evidence in a case, will be supported by a certificate. So if you're a defence counsel, you're looking for a Section 95 certificate, which effectively provides that the document can be admitted into evidence because it does comply with those preconditions. So Section 95 certificate. And Carolyn and Cohen, it's a district court case from 2011, is interesting in terms of how this works in practice. So in Carolyn and Cohen, which is 2011 QDC 183, the defendant was charged with demerit point driving whilst demerit point suspended. Okay, so you get some demerit points, you're suspended. If you drive, that's an offence against the Traffic Act. The prosecutor introduced computer records from Queensland Transport pursuant to Section 95 to prove that the person received correspondence from the department. That is, correspondence giving the defendant a right to choose between a licence suspension or a good behaviour bond, and the court accepted that material into evidence. Otherwise, could you imagine the nightmare for prosecutions having to call into evidence the person who actually looked on the computer screen, wrote a letter to the defendant saying, your license is now suspended, but you can use the good behaviour bond option. Things don't work like that now. A lot of it's just computer generated. It comes out of the machine automatically in accordance with pre-programming. So the Section 95 certificate basically says all of this information was fed into the computer properly, the computer was operating correctly, all of the information is part of the activities of the department, and the court said, yes, we will accept that as evidence and we will accept it as truth of the information contained within the certificate. And that's the whole idea of it. So we've got a good idea of Section 95, so pretty important. A derivative is 95A, that deals with DNA evidence. And other sections that you might consider. Section 96 deals with inferences concerning admissibility. So the court may draw any reasonable inference from the form or the content of a document in which the statement is contained. Section 97 deals with that process of authentication, which is producing a copy of the document that will be sufficient if the court approves it. 98 deals with rejection of evidence. The court may reject any statement or representation. 100 deals with corroboration. For the purpose of any rule of law, requiring evidence to be corroborated, a statement rendered admissible by evidence in this part shall not be treated as corroboration. Section 101 deals with previous statements by a witness. Section 102, I've already mentioned, that is the weight which shall be given or may be given to any evidence. And of course, Section 130, the overriding discretion, which is based on the Christie discretion, is the opportunity for a court to reject evidence. This is in criminal proceedings, in circumstances where the court is satisfied it would be unfair to the person charged to admit that evidence. I say it's the Christie discretion because that was the original case upon which that section was based. Oh, I've been doing a lot of talking. You're doing very well. Okay, no questions? All good? All right. The only other section that I think is relevant is have a look at Section 84, maybe 83 as well, which deals with books of accounts. So entries in books of accounts can be evidence of matters, transactions and accounts. In a book of account, in those circumstances, have a look at the definition of book of account. It's in Section 83 of the Act. So 83 basically talks about a document used in the ordinary course of an undertaking to record financial transactions of the undertaking or record anything acquired or dealt with in relation to that undertaking. Okay, so the main thing is to identify the main provisions, probably make a flow chart if you can, definitely make some sort of short summary. Maybe for the purpose of the work that you might do for the examination at the end of the year, maybe prepare some draft answers. Have your statement of the legal position ready to go, maybe catering for a few different circumstances. If you haven't already had an opportunity to look at this, I think somewhere on Moodle I've put what I call Level 3 preparation for examinations, and it's my take on how you should go about preparing for exams. So as we get closer to the end, you'll find that I talk more and more about the exam. Okay, so far we've been talking about the Queensland Evidence Act, 1977. Remember, of course, the Uniform Evidence Act, which for our purposes is the Commonwealth Evidence Act, 1995. There, again, start with the hearsay rule. Start with Section 59, which is the general rule banning the admission of previous representations. which is essentially hearsay. Section 59 talks about the exclusion of hearsay evidence and previous representations by a person as not admissible to prove the existence of that fact. But, as you might expect, there are exceptions. The best way to guide your way through the Federal Commonwealth Evidence Act is to look at a really handy flowchart, and you'll find this on page 35 if you've got the print version. It's essentially at the start of chapter 3. I'll just show you on the screen. See that flowchart? It's actually part of the legislation. So that's a great way. And I actually use that. There you go. Sam's got it. I actually use that when I'm looking at state legislation as well, because even though the section numbers don't work, it's a very handy way of identifying whether something is inadmissible or admissible. And it's very logically set out. So that's a great thing to consider. So have a look at section 59 and then consider other sections. And I'll just go through them. You might just want to jot them down briefly. Or if you're watching this as a recorded session later, pause and have a look at the sections. But in conjunction with 59, have a look at 60, 64, 66, 66A, 69, 70, 71, 72, 73, 74, 75, 81, 87, 92, 110, 111. Oh, that's a lot of sections, isn't it? But they're the important ones that you need to consider. With a lot of that is in the context of documentary evidence. For example, 69 deals with business records, 71 deals with electronic communications. So there are some exceptions, there are some examples, and you can see those examples actually in the legislation. So not only is there a flowchart in the legislation, but there are worked examples, and the list that I mentioned is actually drawn directly from the notes as part of section 59 of the Act. And the examples are at the tail end of section 59, and there are 3 that are nominated. I won't read them, but I would urge you to read those examples and understand them so that you have a good idea of how the hearsay rule works generally within the context of the Commonwealth legislation. I know we're not talking about hearsay yet, but I can't talk about documentary or real evidence unless I talk about hearsay also. All right, so have a look at those sections. I won't go through them in any detail beyond what I've just said. Look at the flowchart and consider it in that regard. Now, I know that basically tonight I've been talking about documentary evidence. And you'll say, but isn't it documentary and real evidence? Well, to be honest, real evidence is really simple. Real evidence is someone coming along and producing a thing for the sake of the thing itself. As I mentioned at the start, the knife, the bloodied shirt, the baseball bat, whatever it is that you're looking to prove, you know, in drug matters, it might be the drugs themselves. They're items of real evidence. And what we're interested in is the thing itself, which proves something. Doesn't matter what's written on it, we're looking at the thing itself. And that's about all I need to really explain as far as real evidence is concerned. Okay, again, thank you. You've been very patient. I'm just about to wrap up. Any questions? All good? All right. So for those of you who have completed your first assessment, thank you very much. For those of you that haven't, we look forward to seeing you in that context as well. And soon, if not now, you should be on to the second assessment. And it's a fun assessment. You've got a choice of movies, but feel free to watch both of them. They're both great, and answer some questions in relation to those movies. All right. I'll end the session now unless there's any questions. All good? All right. Thank you very much for participating, Samantha and Vivian, and we'll see you next time. Bye then.